They will not allow you to insert words like maintenance. They will not allow you to insert words like fine collection, levy of fines, or anything which has to do with monetary business transaction or service transaction. Such items will not be allowed to be inserted in the bylaws of the association. So basically, the purpose of registering a welfare association is for the purpose of collection of maintenance is defeated by the High Court judgment. And tomorrow, you may ask, what is the consequence? We are still under 1960 Welfare Association. What can happen tomorrow? Yes, the consequences, it's all good when all apartment owners are happy. But if somebody wants to cause some nuisance, he may go and file a complaint before the registrar seeking to cancel the registration of this association with the reason that this association is collecting maintenance. They can give a straightforward reason that this association is not performing the objects of section 3 of the KSRA 1960. They can give the reason in writing. They can ask for cancellation of the registration certificate. So this defeats the entire purpose of registering apartment association under Karnataka Societies Registration Act 1960 after the 2019 verdict. So coming to the next type of apartment association, Karnataka Apartments Ownership Act 1972. Now let's look into when all the how the registrations have happened, how the builders have made a fool out of a resident to make you believe that you are a registered association. So I have been visiting the Co-operative Societies office, Malleshwaram, and Ali Askar Road, the registrar's office there, for quite a number of, since 2015, I have been visiting every year. Only to be rejected about any inquiry for registration of apartment association under 1972. So till date, if we look into, if you may ask me, like how many apartments are registered under 1972? Not a single apartment are registered under 1972. But how are they made to believe that you are a registered association? Here, the Act itself has many flaws. One of the flaws I would like to discuss is the Act in one of the section in the Karnataka Apartment Ownership Act. It says the deed of declaration and bylaws should be filed before competent authority. So the words used, DOD and bylaws, should be filed before competent authorities. The Act does not say DOD and bylaws should be registered before competent authorities. So the builders have manipulated this one section in the KAOA 1972 Act in their advantage. How they have misused now let's look into the purpose of DOD. So what are the purpose of DOD? So deed of declaration, what is the purpose of this document? This document is only for the purpose of declaring declaration of the land, the structures built on the land, and for all the amenities provided by the builder towards all the residents, and also declaration of undivided square feet area. This is the only purpose this document serves. Now, how the builders manipulate this deed of declaration document is they insert bylaws into this document. So bylaws containing the administration, election part, maintenance collection part, all these rules are inserted into this deed of declaration. They present it before the sub-registrar, who is a revenue authority. So let's understand what is the jurisdiction of a sub-registrar, a revenue authority. His jurisdiction is only to decide upon the stamp duty to be collected, upon the area, land extent area, but he has no role in registering the bylaws of the association. So here again, it's a bribe culture which has been followed. So builders bribe the sub-registrars heavily. They allow the sub-registrar allows to insert the bylaws into this deed of declaration document. The builder, the fees he pays towards the sub-registrar is for the additional pages he has inserted into this deed of declaration document. The fees for registering this document is hardly, government fees is 2,000 to 3,000 rupees. And with this deed of declaration, with the inserted pages of bylaws, he will impose it upon the residents, and he'll make you believe that you are a registered association. And there is one more flaw in the act. The deed of declaration and bylaws should be filed before competent authority. Now, the builder cleverly, if he goes to file it physically before the either Malleshwaram or Aliaskar Road, if he goes physically to file the registered DOD and bylaws, the registrar rejects the physical filing of this DOD containing bylaws. He gives a reason stating that I have no powers to register deed of declaration. I have no powers to register or to accept filing before me because no powers have been conferred upon me. I had filed one RTI. I'll just share that. So this is the transcript translation of that RTI. So they have clearly stated. We had asked the question regarding do you have powers to register apartment associations under 1972 because they are the competent authority. They have replied back, no powers have been conferred upon them to register associations till date. So it is clear from their reply till date, not a single apartment association is registered under 1972. It is just that the associations have been made to believe that they are a registered association by the flaw in the act itself, in Karnataka Apartment Ownership Act. And recently in our state legislature, one Mr. Nadagowda has questioned it before in the parliament, where he has questioned whether bylaws can be registered under 1972 provisions before sub-registrar. So when he has questioned, the urban development department has further put this query before the legal department. The legal department has to answer this question whether sub-registrar has power to register bylaws under provisions of 1972. The legal department has not yet come with a reply. They may come with a reply in coming days because only last month it has been just been 30 days. This question was posed in the state legislature. So, and in that same question, the registrar of cooperative societies have replied that bylaws of the association can be registered under provisions of Karnataka Cooperative Societies Act 1959. So they are clearly allowing only to be registered as a cooperative society under provisions of Karnataka Cooperative Societies Act 1959. So it is clear from the reply of ROCS, Registrar of Cooperative Societies, that 1972 registrations are not happening, and our legal department of the urban planning department are yet to reply to the question posed by the Nadagoda, one of the members of the this thing. So we again went ahead and we filed one more RTI. So in the year 2020, they have they have passed a new notification. I don't have that notification number, but in the year 2020, the practice of registering apartment association as a cooperative society started. So even though the year of the act, Karnataka Cooperative Societies Act 1959, for the purpose of forming apartment cooperative society was started only in the year 2020, because till date this act was mostly utilized for the banking system, the cooperative bank system, or for any local dairy business, wherein in villages and all they have a dairy cooperative system scheme. So only for such purposes this cooperative society scheme was started. But later now, in the lines of Maharashtra model, we have copied the bylaws of Maharashtra. The same set of bylaws is being allowed to be registered under the Cooperative Societies Act. They will not allow you to they'll not allow you to use your own bylaws for forming a cooperative society under 1959 Act. So it is clear that in the Karnataka Apartment Ownership Act 1972, till date, not a single apartment is registered, and several PILs have also been filed before several courts. In high courts, several PILs have been clubbed together. Even I have also filed one PIL to implement Karnataka Apartment Ownership Act 1972. So wherein they have recently the High Court gave a rule nisi order, because the state government has not come forward to file objections. The High Court went ahead and gave rule nisi order, meaning that only when state government comes to file objection, then the case will be opened for arguments. Rule nisi means only when condition A happens, then the court can proceed to the next stage for arguments. So the rule nisi, only when state government files objections, the state government may file objection or may not file objection. It is totally their discretion. So almost some 20 to 25 parties have impleaded in one single case for questioning the 1972 Act. It's still in court. Now, you may ask, what is the legal stand for registering apartment association under 1972? High courts in two other judgments have recognized that association is valid for the purpose of collection of maintenance. There are three flaws under 1972. I would like to tell. The three flaws are, the first flaw is interpretation of the bylaws. Suppose let's assume a condition that if two executive members have their divergent opinions about the bylaw, how to interpret. Because here there is the competent authority mentioned in the Act has no powers given to him by the state government. So it begs the question that who should interpret the bylaw? Mostly under 1972, it is all builder-made bylaws. So builder copies the bylaws from here and there, and there is a possibility, very good possibility, that tomorrow residents may start a fight and they may dissolve the executive committee meetings, or they may dissolve the executive committee body without without approaching a competent court or authority. So these kind of possibilities are there. So this is one drawback. And the second drawback is election disputes. If there is any mischief done during elections, even that also cannot be questioned before proper court, because nobody knows how the court will look into such facts. Till date, I have not come across any situation where they had challenged the elections of Apartment Welfare Association, and how the court may, whether will court ask the competent authority in the act under 1972 to go and look into the affairs. I have not come across. Because even if the court asks the competent authority, that is the registrar of cooperative societies, to come forward to handle the disputes of elections, then the cooperative, there is a good chance that cooperative society can say that I do not have powers to look into the affairs of association registered under 1972. So you go, so I can't help this court. He can clearly say, because the state government has failed in making rules, jurisdiction, defining powers and duties of the registrar of cooperative societies. They have just drafted an act in 1972, implemented in 1974, but they did not give any powers or jurisdiction, roles and duties for the competent authority under the Act 1972. So, and the third dispute is misappropriation of funds. So how is your funds getting utilized? Whether if any misappropriation happens under, if you are a registered association under 1972, then again is a question. So who should the people approach? If they approach civil courts, whether do they get a remedy, or how will civil court look into the act, and whether will they again approach the competent authority to do an inquiry, is all a very trivial, tricky question. So 1972, in my opinion, if tomorrow our legal department of the urban planning department comes with a reply that the sub-registrar authority, revenue authority, does not have any role to register bylaws, then it may totally defeat all the existing associations. So if it may happen, because legal department can say that if tomorrow that whatever all the registered associations who themselves declare that they are registered associations, if if the legal department comes with a reply that registrar or sub-registrar or revenue authority does not have any powers to register the bylaws, then this total act itself is defeated. Now coming to the what is the legally recognized version of running association, I would only like to say is Karnataka cooperative under you can form a cooperative society under the provisions of Karnataka Cooperative Societies Act 1959. Is my screen visible?
Yes, sir. It's just a little light. If you can expand it. Zoom. If you can zoom in. Yeah. This is better.
Yeah. So the only legally recognized apartment association so far now in Karnataka is only 1972. Yes, 1970. If you may ask me, is 1972 good? Yes, if all are content and happy, only to collect maintenance and run the association, and they don't have disputes regarding disputes regarding interpretation of bylaws, misappropriation of funds, election disputes. If they do not have such issues, they can go for 1972. And so if they want a proper authority or to approach a proper authority for any grievance, then they need to register as a cooperative society under 1959. So this 1959 started only in the year 2020. During the COVID time in the year, during June month, a notification was released that associations can register as a cooperative society. So the practice of registering apartment associations as a cooperative society has started after that. In the year 2020, hardly 5 or 6 newly formed cooperative societies were registered. In the year 2021, I have seen almost some 20 to 25 associations migrated from either 1960 to 1959, and some have migrated from 1972 to 1959 also. So looking at the difference between 1972 and 59. So 1972, there is no registration certificate available. So the only source document for you as an association is that deed of declaration inserted with the bylaws. So the bylaws, the sub-registrar does not have power. He will just register, even though he does not have the jurisdiction to register bylaw, he will register, and he will that document is imposed upon all the residents to make you believe that you are a registered association. So 1972, it is totally builder made bylaws. So under 1959, yes, registration certificate available. So registration procedure is defined. So how the filing, so the builder cleverly, one more point I forgot to tell. So builder, it says DOD and bylaw should be filed before competent authority. So there is no provision to file it physically before the registrar of cooperative society. So these builders send it by post. They show you that they show you that postal acknowledgement. See, my dear residents, I have filed it before the competent authority following the provisions of 1972 because I have received the postal acknowledgement and I have filed and I have followed. Now you are a registered association. Go run your show. He'll just hand it over and he will let go. So one more thing I would like to say regarding handover from the builder to the association. So what is a complete scheme of handover, you may ask me. So in the only scheme is recognized in states like Maharashtra, and recently I had Kerala also. So what happens in Maharashtra is that when builder constructs an apartment and he has to hand over, he also has to register the entire land area in the name of the cooperative society. So that scheme is not available in Karnataka so far. So because our state governments have not worked in that line to allow such scheme to come into existence. In Maharashtra, with the nominal fee, the builder has to transfer just paying fees within what is this? So the procedure of handover of the towards the cooperative society in Maharashtra, the scheme is the builder has to register the land area in the name of the cooperative society. Unfortunately, our state governments have not come with the same scheme of transfer of land in name of cooperative society. Our state government recognizes transfer of land only by payment of stamp duty towards the government. So if again you are already paying stamp duty towards purchase of apartment and also towards UDS, but if because our state government has not allowed such scheme like Maharashtra, so if again any cooperative society wants the land to be transferred in their name, it may run into crores together. The stamp duty may run into crores together, which defeats the entire purpose of transfer of the land in name of cooperative society. Why? Because in Maharashtra, the apartments which were built in 1970s came for demolition in the year came for demolition in the year 2010, which led to because the cooperative society again were at the mercy of builders for no objection certificates, plan approvals. They were still with the mercy of builders, So a big movement happened in Maharashtra, wherein the state government recognized these issues. The sea-facing structures, apartments were subject to erosion and uh, they had to be demolished. So for new permissions, the state government of Maharashtra came with a scheme of conveyance deed, wherein the builder could transfer. If builder is refusing to transfer, the state government again in 2014 or some year, they came with a scheme called deemed conveyance deed. So in this scheme, the cooperative societies can themselves approach in absence of the builder, and they can demand the registrar, sub-registrar to register the land in name of the cooperative society. This scheme of deemed conveyance deed was available in Maharashtra. So in recently, I also was talking to one of my friend in Kerala, wherein they follow that Kerala Apartment Ownership Act 1972, wherein they allow the district collector to register the land in name of the association under 1972. Unfortunately, our state government has followed the path of Maharashtra by allowing the same model bylaws to be followed in Karnataka, but they have not introduced the scheme of conveyance deed like in the lines of Maharashtra for handover of the maintenance and all the other bylaws and also the land in the name of cooperative society. Here, the handover process understood in Karnataka by our residents here, apartment residents or villa residents, is that you take all the originals from the builder's possession in your possession, and you take all the maintenance, housekeeping, everything from builder's hands into your hands. This is the only understanding our residents in Karnataka so far are having. So the law has to mature. Our legislatures, the lawmakers have to bring in security safeguards like Maharashtra and define the handover process. So then cooperative society scheme will be a very good scheme. So what are the positives, you may ask, about Cooperative Societies Act 1959? Yes, the three disputes which I mentioned with 1972 is getting addressed in 1959. That is the election dispute, misappropriation of funds, interpretation of bylaws, for which you can approach the competent authority. So, and one more, for maintenance collection. If somebody is defaulting on payment of maintenance, under 1959, under the bylaws, you can approach the registrar of cooperative societies. You can ask him to attach the assets of such defaulting person to recover the maintenance. But under 1972, if you are registered, if you are an association under 1972, such association will have to approach city civil court. Initially, such association may have to run the case for years together, 2 years, 3 years, get an order, again file on execution, recovery. It may take a time of 3 to 4 years for recovery of maintenance. And for any interpretation of bylaws, the registrar will be the final authority. If two members are having any disputes, one is interpreting the bylaw in his own way and another person is interpreting, for such dispute, that registrar will become the final authority to give a decision. And even for same elections, there will be no disputes under 1959 because elections are conducted once in 5 years in presence of government officials, because they are short staffed. And the main drawback is in Karnataka, most of our apartment associations are in the habit of running the association for a 1 year term or maximum 2 year term. And you may ask question, can we amend the bylaws and reduce the 5 year term to a lesser term? It's not possible because they will not allow if to amend the main provisions for election provisions. And one more drawback about 1959 is the executive committee members are limited to only 13 in number. Most of the apartment associations are having executive committee of more than 13 or 17 or 21. But here under 1959, it is limited to 13. Out of these 13 members, 9 are from general category. 4 people should be from SC, ST, OBC and minorities. So there is reservations also under this executive committee. Only these persons of this category can contest for elections. So you may ask me like what is the procedure to form a cooperative society? So initially there are 20 people required. 19 people will be called as promoters. 1 person will be called as co-promoter. So these people will have to sign affidavits, the bylaws, and the application for formation of cooperative society. They have to submit it. Once they submit all this documentation, a caseworker is appointed. A caseworker will visit your apartment premises. Then he gives a feasibility report. Yes, you can form a cooperative society. With that feasibility report, again, the registrar of cooperative societies will give an order to open a bank account in district cooperative bank. Okay, district cooperative bank run for only for the cooperative societies. At this bank, a minimum deposit of rupees 2 lakhs has to be made, and this 2 lakh should be collected from all the members as for share certificate. So each share certificate is of value of rupees 1000 and plus 200 rupees for additional charges. So 1200 rupees should be collected from every member, and the minimum deposit, it should be 2 lakhs. Once you collect all the membership fees and deposit in the DCC bank, then you'll also have to circulate applications for membership in the cooperative society. You have to get personal details of all the members who are interested to become members, and then thereafter you have to issue share certificate to every such member. So you may ask me, what is this membership value? If somebody does not become a member, what can the cooperative society do against him if he defaults in payment of maintenance? See, this cooperative society is formed by majority of residents. So straightforward, when it is formed by majority of residents, this bylaw is imposed on such person. If he does not become a member, he will still be liable to pay maintenance. Okay, so by becoming a member, what rights do I get under cooperative society? 3 important rights. One is right to vote in elections, right to participate in general body meetings. Third is right to contest for elections. Only if you are a member and you have not defaulted for more than 2 months while paying maintenance, then you can contest for elections. So these are the rights of a member under cooperative society. So these are the difference between 1972 and 1959. Under a few more differences, renewal is compulsory under 1959. Under 1972, it is there is no renewal process mentioned under 1972. They just keep the books of accounts open for the residents to waive it when they are asked. Such provisions can be made under 1972, but under 1959, every year an audit report has to be filed. The resolution book containing minutes of meeting has to be filed. before the cooperative society has to be renewed, paying a nominal fees every year. So under 1972, can I get the land transferred in my name, in the name of association? You may ask me a question that I will say no, because you do not have a certificate of registration as an association under 1972. But under cooperative society, can I get the land registered in my name? Yes, you can get the land registered by paying stamp duty. Just like the stamp duty you pay for sale deed, the same way you pay stamp duty, you can get the land transferred from the builder in your name. It's possible, unless our Karnataka state government changes the scheme and to allow conveyance deed to be made. So we have just walked half the path following the Maharashtra model, but this conveyance deed scheme, if it comes tomorrow, this cooperative society will be a very strong act, in my opinion, in Karnataka. So any doubts, clarification, I'm open for the audience. I'll answer any doubts you have. Yeah.
Naik sir, if you have the document that I have shared with you, this is Ramnath here.
Yes, 1 minute.
I have listed down a few questions.
Yeah, I will
Some
open.
of them I think you have already answered in your session. But if you could just go through that, and of course the other participants are welcome to ask your questions.
I'm just opening your document. 1 minute. My WhatsApp is taking time.
Hello.
Yes, sir.
Mr. Abhilash, this is Vasudevan, practicing civil engineer in the field for about 30 years.
Yes, sir.
I am also one of the resident owner here from 2003. This
Yes,
is
sir.
almost 19.
Yes, sir.
You have for clarifying the difference between the forming a cooperative society under the 1959 Act and also under the 72 Act. We feel that your 1959 Act is watertight and it's good enough. But in the absence of all this funding to get through this Act, at present the registration is under the KSRA 1960. So what if all the residents refuse to pay the fee to register as a, like what I understand is registering as a cooperative society is nothing but like we are running a cooperative bank, like cooperative credit society, something like that. So all those procedures like we follow in a, a business entity. So similarly we have to follow. But here the job itself will be whoever runs the society, like for example the managing committee, what you said, will all be honorary members. And in the absence of revenue coming out from the members, what will be the solution? Anyhow, the association has to be run. And when 500 and odd apartment flats are there, month on month, CMC to be collected, all those daily routines have to be conducted, and housekeeping and other things are to happen.
Correct.
So where we get stuck, how to proceed?
Sir, recovery under 1960, you can approach civil court, but only the loggerheads. If such defaulting person approaches for cancellation to take, he has a revenge-seeking attitude. Because I'm a legal advisor for one of the villa associations. So few owners have 5-6 owners have went against 170 owners who are running the association under 1960. They have went and filed a complaint before Registrar of Cooperative Societies. The existing executive committee decided to dissolve the committee because they are legally not correct to run under 1960 as a association for the purpose of collection of maintenance. So they dissolved it and they have passed a resolution to migrate from 1960 to 1959. So, but under civil court, you can still pursue the case for recovery of the maintenance from the defaulter. And if you are still under 1960, that does not bar you from recovery of maintenance, because maintenance is the collection is the lifeline for providing all the services for an apartment association. Legally, you can collect.
Yeah, right.
Yeah, but tomorrow it is also subject if such association will withstand the pressure from such person if he knows the law about 1960.
Yeah.
Yeah.
But basically, is there any reprieve from the stamp duty payment to get registered as a cooperative society, or maybe a reduction or something like that? Because this, as you said, the amount goes very high. Is highly difficult to generate this type of revenue from the members to register as a cooperative society.
See, there is one more solution for this.
Yeah.
Oh, tomorrow you are telling me you have some 500 odd apartments. Tomorrow you call for a general body meeting, and I know the attitude of residents. Hardly if you get 10% or 20% of all residents coming and attending a general body meeting, it's a very good number. Exactly. So in such scenario also, you just need 20 people to start. Okay, you pass a resolution in the general body meeting for migrating to 1959. Slowly, you call for elections and you bring it to the notice of all residents that we are migrating under 1960 to 1959, because it is legally not correct to collect maintenance under 1960 Act. So we'll be migrating. This way, you tell them, you collect membership drive. If somebody does not want to become a member, no issue. You go ahead with whatever numbers you have got. Tomorrow, this bylaws and everything will be imposed upon such resident who is not a member. So that way you can form a cooperative society and run the show.
Then I was speaking about the type of amount to be paid as stamp duty and getting it registered.
No. Yeah, no. See, I did not till date not a single conveyance, the stamp duty, single land transfer has been made in name of cooperative society for the purpose of apartment maintenance. I'm only saying that in Karnataka, the scheme like Maharashtra has not been recognized for the scheme of wherein in Maharashtra you pay a nominal fee of 5,000 or 10,000 and get the entire land in name of cooperative society. That scheme does not exist in Karnataka because our Karnataka government only recognizes conveyance by way of sale by payment of stamp duty. So here you need not register the land in name of cooperative society, but here you will only register the bylaws before the cooperative society. You don't. Here you are only registering. You are migrating from 1960 to 1959 without the land being transferred in name of cooperative society, but still the bylaws are valid. It is imposed on all residents, even if they are not members.
Okay, that means to say practically minimum number of 20 people should join together, collect the required fee, and register with the minimum payment of 2 lakhs and proceed.
Yes. Yes, sir.
Thank you for the clarification.
Yes.
Sir, I have a question.
Yes.
Sir, I'm Prashant.
Yes, sir.
Sir, I mean, see, most of the cases where I have seen, they have registered apartment owner associations under KSRA Act 1960. And then they are collecting the maintenance, they're running, they're happy. So is there any problem, if they continue, or if anybody wants to form a new association, is it advisable for them to go under registration for KSRA Act 1960?
Sir, if it is a smaller one within 50, within 100, yes, because they lack funds, you advise them. If they are a bigger association, more than 100, you advise them to go for 1959. Because the expenses itself will come, will touch near all the bribe part, everything will touch near 4 lakhs.
Okay, okay, sir. Thank you.
Okay. Ramnath sir, any particular question I want to answer?
No, sir, you have seen the list of questions. See, primarily, my question is like today, though we are under KSRA, we don't have registered bylaw. So is it legal to conduct elections? That's number one. And the second thing you said is that it is illegal for, it is violation of section 3 rather, when you're under KSRA to collect maintenance charges, correct?
Correct.
So one contentious issue that is going on in the recent past, recent times, is that there is an underpass project which BBMP is undertaking, and a portion of our land is being acquired for a consideration of 6.63 crores.
Yes,
okay.
sir.
So now in this scenario, is the association legally entitled to represent the residents, even under KSRA, to collect the money from BBMP, or the association is not supposed to get involved and they have to ask BBMP to pay the money individually to owners depending on some formula?
Sir, generally, both the options are possible, but here it becomes an undivided because only a portion of land is getting they are acquiring only a portion of land.
That's correct.
Now the problem here comes is how to divide this money amongst all the residents. If majority in a general body meeting, if you decide, yes, this money has to be transferred to all owners depending upon their UDS, then you may be required to appoint an independent auditor and calculate all the required compensation to be transferred to such owners can be possible. And if tomorrow many in the general body meeting, you decide that you'd majority do not come forward and they say that money should be in the hands of association to utilize it for building repairs or administrative work, even that suggestion can also be accepted. Both ways are possible.
But isn't this a contradiction of the section 3 then? Violation? Because section 3 you said none of the monetary matters can be dealt with.
Sir, all is good. Sir, running association is good till the time no resident goes and complains before the registrar of cooperative societies for cancellation of the registration certificate.
Okay, sir. Okay.
Till that time, you are good to run this association. If all the problem starts only if someone goes and complains before ROCS to cancel your registration certificate because you are violating section 3.
Okay.
So
in this,
tell me,
but sir, since we are paying the property tax and Kata is an individual name, can BBMP still issue a check in the favor of the office bearers? Is it, I mean, irrespective of KSRA, outside the purview of that?
See, here what happens is, again, it's a question. Generally, when lands are acquired, generally when agricultural lands are acquired, such owner is identified. Okay, sir. Who is the owner? That ownership is identified for a land, for agricultural land. For him, the amount is generally deposited in the government bank account or with the court's bank account, and such person can go there and recover that money what has been deposited by the government in his name. But in your scenario, how will because the government has the scheme and power to identify the landowners, but here there are 532 owners.
Correct.
So, yeah, it is a huge job for the government also to
Okay, so it's
identify.
more of a logistical. So you're saying that it is more of a logistical and convenience. Isn't that?
Yes, they will not go and identify all 532 owners, because they will definitely not give notices to 532 owners that we are giving you compensation for so and so much acquired. They'll definitely not do it. It's easier for them to deposit in name of association and exit and acquire the land area. I hope you
Okay,
are
sir.
clear.
Yeah, thanks, sir.
Okay.
But they can use it.
And Nayak, sir, you have addressed most of the questions through your session. But if you could just scan through and see if there is anything specifically is kind of left out, you may want to address it for us.
Post 2019 verdict, is it mandatory to migrate the registration? All is good until nobody complains before ROCS. If somebody is complaining, then you may be required to migrate, because registrar of cooperative societies has power to cancel the registration of your certificate. So what is the timeline and costs involved? So apart from the 2 lakhs deposit, another 2 lakhs or whatever the amount demanded by the registrar may be required, which may go till 4 lakhs or 4.5 lakhs. So since PGO is in existence since 1994, will it be eligible for transfer? Yes, by a simple majority in a general body meeting, you can pass a resolution to migrate to 1959 and you can migrate. So what happens to the corpus fund currently when transitioning to KCSA? You can form an ad hoc interim body to maintain the functions of association till a newly elected body comes in place. Once a newly elected body comes in place, you can give a letter to the bank authorities to change the name of the bank account, and it can be utilized, or the same bank account can be utilized for the bank account which was in the name of welfare association. The same bank account can be utilized for 1959. So how will be in the interim? So the existing people who are running the show under 1960, they can continue till the fresh elections are conducted by the government officials, and when the newly elected people are come into existence, the old elected people can hand it over to the newly elected body under 1959. And KSRA of 1960 is an association permitted to represent the owners and collect compensation from BBMP on behalf of all owners. Yes, they can do so, because BBMP does not recognize whether you are an 1960 association or a 1915 cooperative society. So BBMP can still transfer all the funds in name of association under 1960, and they can exit, stating that we have transferred to all the benefit to all the owners who have formed the association under 1960. So paying compensation individually, So it is also a gigantic task for the government, identifying 532 owners, and some owners are not here. So it is better. My suggestion would be to take, because if they divide that 6.63 crores among all the 532 owners, most of the owners are not here in India. So you will get a only part payments. You will get hardly 50,000 to 1 lakh rupees, depending upon your UDS. So I suggest you better collect it for the building welfare for tomorrow, other repair works or any other operations. So that amount will be well utilized if it's under hands of association or a cooperative society. I think I have answered. Now 10.
Well, Mr. Abhilash, I have one question, last and final. It may take 2 minutes.
Yes.
So suppose you said the BBMP is okay, you cannot identify all the 542 owners and individually tackle. So they will be more, they will prefer only transferring to the association, and then in turn the association can internally transfer the individual amounts as per the calculations, right?
Yes.
So in case the present any of the members or majority of the members have an issue with the functioning and the way of administration of the present committee, that is the association, which is association managing committee, is there a provision that the aggrieved people can approach the registrar of societies and ask for appointing a body to oversee this transaction of collecting the amount as well as keeping it in a particular specific amount account newly created only for this purpose?
Yes, can be done, but general body meeting resolution has to be passed.
Okay. But then the general body will be held by the same existing administrative body only.
Generally, see if they listen to you, you give them a carrot. If they don't listen to you, you give them if they listen to your demand, you give them a carrot. If they don't listen to you, you give them a stick.
That's it.
Yeah, you give them the stick of section 3. That's all.
Right. Thank you.
If you have such a demand, that's all. You have to corner. If you want to corner them, you will. If you don't want to corner, it's your choice. What happens in a scenario if two associations exist, one under KSRA? Obviously, the 1960 registration will get cancelled by virtue of 1959, because the purpose of 1960 is different, so it cannot run for purpose of collection of maintenance. Because both the competent of the registering authority for 1960 and 1959 are the same authorities, registrar of cooperative societies. Only they are having the register to bifurcate you in under which provisions you need to register association or a cooperative society. In 1959, it is better because there is much teeth and watertight compartments for many issues can be addressed before the registrar, but 1960 not so much. Can the association cut off water supply, electricity in cases of non-payment of maintenance dues by members? Electricity, definitely, it is a government commodity, you cannot cut. If water supply, unless you are providing water by tankers and you have installed private pipelines for each individual apartment, or you have some scheme that such person is not sharing the water expenses for all the private water, unless it is Kaveri water and metered water, you cannot disconnect. but only in cases of private source of water. And there should also be a private meter and private supply bar attached to such water supply. Possible. Is association empowered to cancel or debar the membership of owners on grounds or operational register? No, not possible. Cancel or debar or membership of owners on no. See, one thing, you cannot just cancel the registration because you just don't like him. See, only on 3 grounds you can challenge a members act. One is his morality grounds. If collective executive committee members can take a decision and remove one of the member, possible, or they can remove on grounds of any morality or any under the contract act. Few grounds are there. And also the other residents can challenge if there is any executive committee members decisions for misappropriation of funds. If there is some misappropriation, if there is clear-cut evidence with such person, just by allegation won't help to prove the case unless he has some facts with him or some evidence with him for such misappropriation of funds. Yes, you can challenge. And any decision passed by any member which is in contrary against the welfare or which is supporting a minority group against the majority group, or any such decisions which is not in which is not in giving welfare to all the residents, such decisions can be questioned. Misappropriation of funds, interpretation of bylaws, yes, can be questioned. So any other doubts or any clarifications people want me to answer, I'll answer.
Thanks a lot, Naik sir. As I think as other people might be thinking of some questions, I just wanted to ask one final information from you. So in what capacity and how does you engage with apartment associations?
Generally, I will we have to connect outside this meeting for all the fees and details. So
Sure.
generally, I work on retainer basis. If people, if the association wants me to appoint on a retainer basis, there is a fees charged monthly basis. If they only want my services for registration of cooperative society, I charge a separate fees. If they appoint me as a retainer, I charge a reduced fees. That's all.
Sure. Thanks a lot, sir.
Welcome, welcome. If you want me to share this recording of this meeting, I will circulate it. I may put it on YouTube and I'll circulate that link.
Yeah, please, sir. Because I was anticipating a lot more participation. The participation is quite
You
poor.
can
So this record will be, we can share it and it will be useful for us.
Sure. Okay, sir. So
Okay,
thank you.
sir.
Yeah.
Thank you.
Thanks a lot for your time. It was a very good presentation. We at least have the awareness and knowledge, and hopefully we'll take the right steps.
Sure, sir. Oh, right.
Mr. Abhilash, this is Ramanan. I had one question. Sorry, the last moment thing.
Yeah.
I was just thinking about that morality question about ousting some member from either the association or from the society. Now, we have a peculiar case where we have 12 blocks and 24 members get selected. Out of 24 members, we bring in a 12-member management committee who will run the association. Now, there is a draft bylaw which they had been following from the time the association has been formed. And as per that bylaw, it says that if somebody is proven guilty in any cases, any owner who has got a case against him and he is proven guilty, he may not contest for election, he may not be elected either.
Correct.
Now, what if what if a resident owner who is a member has a criminal case against him which is pending in the court?
So
how do we consider him under the morality ground?
So we cannot remove him unless there is proper conviction or anything. Because these
the case is going on for number of years.
Yes.
So,
The rules are strictly we can be stricter under 1960 if such person has a criminal he's accused and the criminal case has been going against him.
Yes.
Such person cannot be removed until he is proven guilty.
Okay.
So only
but if one could argue that in the Indian scenario where such cases goes for number of years, 5-6 years it gets contested, and at the end of 5-6 years he may be acquitted or he may be punished for crime what he has done.
yes.
But during that period, keeping him in the association, giving him some senior post, will it not be harmful, particularly if the man is charged for physical abuse?
Our state government is only appointing all the corrupt officers to run the show of the government, because only for the reason that they are not proved guilty. Yes. I think the same rule applies here also.
All right.
Yeah, of course.
Naik sir, I just had one question which just came up, which I forgot to record. A couple of months back, the elections were held. And one exception the management committee has done is that they have allowed spouses of members to get elected to the committee. Here, when I say spouse, they are not co-owners. They are not co-owners in the sale deed, but they are spouses. Okay, ours is Grihalakshmi Apartment Owners Association. Is that allowed? What kind of candidates are allowed? And the other very important question is, there is no provision or rule which says that the membership is only, election participation is restricted only to resident members. Are both these legally tenable?
Sir, when we run an apartment association, because 1960 again the bylaws, how you have defined bylaws, it's again another question which has to be interpreted. That's one thing. General, the basic rules we follow. When I deal with almost some 4 RWAs where I've been appointed as legal advisor who are under 1972, and few 3 of them are under 1959 and 2 are under 1960. So here bylaws we have defined in all our bylaws, we have defined only owner. The first name in the sale deed will be allowed to become a member of the association. So if the second person, if the first person does not want to be a member and he wants to allow the second owner in the sale deed to become a member, that first person has to step down and allow the second person to become a member. This member has a right to participate in GBM, vote in the GBM, and he also has a right to participate in the elections. So this rule is followed strictly. So if spouses who are not, their names are not found in the sale deed, if there is a provision in the bylaws of your 1960 that an exception can be made for the spouses of the owners of the apartments, if that rule is available in your bylaws, then it holds good. Otherwise, the owners have to compulsorily become the members to run the show.
Okay, sir. And the second question, can the membership participation in election be restricted to only resident members?
Yes,
Under
here
the
because, yes, because here we faced a similar scenario. We made a rule where I'm legal advisor for Prestige Tranquility. Only a resident, he maybe have purchased a flat, but he's not living here. He's living outside. Only a person who is living inside the apartment should be allowed to become allowed to contest for elections. This rule is very much applicable under 1959. He may be living outside, but he wants to contest for elections. It is not possible under 1959 as per the bylaws. But it depends upon how you have drafted your bylaws. I have not read your bylaws, so I cannot go ahead and tell what are the rules, terms, rules and conditions you have drafted. Yeah.
Sir, when you're under 1960, just on the bylaw, I'll just take a couple of minutes. I'm sorry, something's missed my mind. So, for example, when you're under 1960 KSRA also, the bylaws, who is the competent authority under whom it has to be registered? Because as on date, we are only.
Yeah, am I audible? I think, sir, I understood your question. Yeah, I understood your question. So under 1960, let's assume the main question you need to ask, are there any rules and regulations? Like what rules should be followed to draft a bylaw for the apartment associations? You can ask me question like this. I will only say there are no rules existing under 1960 to frame bylaws for running the association for the purpose of apartments.
Oh, okay, correct.
So
because it's a violation of Section 3 itself. Yes. Fundamentally.
So you just make your own bylaws, and before 2019 they used to allow you to insert any terms and conditions, but after the High Court judgment, even now they have also come with a standard draft. They will not allow you to insert words like maintenance, collection of fines, levy of administration fees, membership fees, or any commercial activity. They will not allow you to do any business with regard to administration, maintenance, repair works.
Okay.
So it is totally defeating purpose. Yeah.
Sure. And sir, who's there? I think I just lost the power. There was a power cut in my house. So who is the competent authority under whom the bylaws in 1960 has to be registered?
Registrar of Cooperative Society, same person who is registering Cooperative Society under 1959.
Oh, the same, like the deputy registrar in Malleshwaram.
Yes, Malleshwaram and Aliaskar Road, depending upon your jurisdiction.
Yes, sir. Okay, our jurisdiction is under Malleshwaram.
Yeah.
Okay, sir. I have no other questions. Do any of the other members have any other questions, or can we close the session? Okay, Naik sir, I think it was an excellent session. We actually got a lot of clarity on many important issues. I think from what we understand is the current scenario, if we want to continue under KSRA, it is a matter of goodwill, a question of trust between the members and the management committee. But if we wanted to become a more professional and a more watertight body, we need to migrate to 1959. Correct, sir?
Correct.
Sure. Okay, sir. Thanks for a wonderful session and your time.
So 1960 works well with all the silent participants who will not question why about the registration. So unless somebody questions, it is like already where we are migrating from 1960 to 59 with one of the Villa Apartment Owners Association. So until and unless residents are silent on the legal aspect of the registration of 1960, it is good to be association under 1960. But only if somebody questions, then all the Pandora's box of trouble starts.
Okay.
Yeah, got it, sir. Thank you for the good session.
Thank you. Thank you.
Thanks a lot, sir.
Thank you. Thank you.
Thank you.